Hello, everyone, and welcome to this Legal 500 webinar sponsored by Freeths, Creating Value by Embracing Risk. My name is Joe Boswell. I'm head of the Legal 500 GC Powerlist series, which you may have heard of, and I'll be introducing today's session. We're taking a deep dive into litigation risk management today, with a mix of both practical advice and technical knowledge set to be dispensed during the coming session that will help in-house counsel of all experience levels. Before we get started, I'd like to quickly remind the audience that the opinions expressed are those of the individuals only and do not necessarily reflect those of the organisations they're a part of. And now I'll spend a couple of minutes introducing our fantastic panellists. Tim Greenwell is currently Chief Legal and Risk Officer at Southampton Football Club, prior to which he was General Counsel for Toyota Great Britain and Assistant Company Secretary at Edwards before that. Ryan Thorne is General Counsel of investment management firm Stonebridge and has also held in-house legal roles with BlackRock and in Australia, Woolworths. Graham Barron is a technology sector in-house legal expert with his current role as VP for Legal Risk and Order at Trustpilot, complemented by senior roles in the legal teams of Skyscanner and Sage. And I'd now like to throw over to James Hartley to introduce himself and begin the webinar. James.
Thank you, Joe. Yes, I'm James Hartley. I'm a litigation and dispute advisory partner with Freeths here in the UK. So welcome to everybody and good afternoon to this discussion. We are focusing, as Joe mentioned, on creating value through embracing risk, particularly looking at litigation and regulation. We are very fortunate to have the panel of Ryan, Graham and Tim, legal leaders in diverse sectors, including investment, financial markets, professional sport, technology, digital collaboration. So really looking forward to the insight that the panel can give to us. And the way we plan to structure this is to move through 4 themes. And I'll ask some questions to Ryan, Graham and Tim, and we'll have a discussion. Feel free, audience, if you will, during the course of this, to send in any questions that you may have, and then we'll look at picking those off as we go through or at the end. And we will pause more or less halfway through to issue a poll question for everybody, which we'll tell you a little bit more about when we get to that stage in the proceedings. The context for this, of course, is that we all operate now in a time of great complexity, great risk, but also great opportunity commercially. And this is all about seeking some insight into how we can all, with our businesses, navigate through all of that whilst creating value. And also looking at value through 3 lenses, effectively. So value for the business, clearly, or the organisation that we operate within, value within the legal team that we operate in, and demonstrating that value, but also value more widely and externally in the context of ESG and the wider social and environmental interests that we all want to focus on as well. So that's the context. Moving in, therefore, to the first theme, which is around preparing for unforeseen litigation and regulatory risk. So preparation. If I could turn to you, Ryan, first of all, with a question around whether you feel or whether you've seen the pandemic having changed the corporate mindset around unforeseen litigation risks in your sector, and if not specifically if not the pandemic having been the catalyst for that, any other evidence of changing mindset around litigation risks within corporates?
Sure, thanks very much, James, and great to be here. Hello, everyone. So it's an interesting question. At first, I wanted to say at a high level, no, I think we had always analysed risk and had the known unknowns and unknown unknowns that you might have in this type of a general analysis of risk management in the company. But I think it has given us a shake-up in a few areas. Certainly, we've paid a lot of our attention to our supply chain. And in terms of a legal perspective, things such as force majeure clauses, material adverse change, or often MAP clauses, they're often called material adverse event clauses, which I think pre-COVID was generally put in agreements, and no one had really given them much thought. But certainly became the forefront when things started turning south. But the interesting thing that I've found in terms of the boards have been acutely aware of these issues from a risk management perspective. But during the pandemic, more often than not, I've found that we've actually worked quite collaboratively with people, even in disputes, even with, it could be a key part of our supply chain, it could be a key contractual counterparty that has its own logistical issues. And there would have been a threat of litigation at the beginning, but more often than not, people seem to come together during that period. We're interested to see how things going forward now, whether that ends up turning more litigious. But from my experience, I think that's been the prevailing theme that I've found during this period.
Yeah, that's interesting, and that of course feeds directly into the whole area of litigation avoidance and planning, which I agree. We're seeing that as well with the corporates that we work with. There is a heightened awareness of what can be done to prepare, and what I often say and what we often find actually in practice is that litigation can usually be avoided, and that is quite a surprising thing for people to hear sometimes, particularly when you're in the thick of it. But actually, the embryonic beginnings of litigation can usually be seen. The real issue is whether they are acted upon and whether they are managed and whether they are then steered in a particular direction, and that involves quite sophisticated strategies and changes in culture in some organizations. Again, it is what we find with our corporate clients. Tim, turning to you on the same theme, really, preparation. From your experience, do companies plan effectively for unforeseen outcomes around the sort of things that I've just mentioned?
Yeah. Hi, everybody. Great to be part of this really kind of interesting topic that we're doing quite a lot of work on at the moment. So, yeah, I think it's mixed still, and I think it's probably a little bit the result of we've seen internally, certainly pre-pandemic, that we started to do quite a lot of work on trying to do contingency planning and planning around certain types of events happening rather than specific events. And it was actually quite hard to get some buy-in internally from different teams, because the thing we always kept hearing coming back at us was, well, that could never happen, or we've got a good relationship with so-and-so, so they would never look to litigate against us, to kind of put it more into litigation terms. So I think using events to help shape us has definitely improved what we do, and I think others, having spoken to others in kind of in-house roles, that it's similar elsewhere, where I think that now there's a bigger understanding that actually, if we'd have planned a scenario around COVID, I don't think we could have gone far enough in making it as elaborate and as long lasting as it's ended up. So actually, we've got a really good opportunity now to use and understand our risks and use them to plan within reason certain responses. And I think that what we see is that what I've seen both at Southampton and also kind of previously at Toyota is that just having enough initial steps set out and a good idea of those initial steps, and it could be as simple as who do we need to go and talk to in the event of someone coming after us for a payout, having had either an accident at the stadium or if we've made a mess of a contract or something. Where do we turn? Who do we get involved? How do we approach this? And I think that planning is really spreading, and I think a real key element to that is where the lawyers can really add some value around kind of risk planning, particularly. Is we see everything almost within reason, or we certainly work with all of our departments, understand their risks, understand what they're doing and how they're working. And so actually that means that we can actually scan the horizon a little bit more effectively and start to look at the types of events that might come our way. And I think that planning has really improved quite a lot over recent times, and probably will continue to do so. I know from my past in banking that the banks tended to do it quite well, although maybe not so well in terms of credit crisis, but did it quite well around certain events. And I think that type of mentality is starting to spread enough. I think increasingly analysing risk, being aware of certain risks and certain potential outcomes is definitely starting to spread.
Yeah, quite right. And the point you made about it can be quite challenging to get buy-in from busy boards who are building a company, and again that's something else that we've seen in our litigation risk advisory work that we've done with our corporates, whereby we've sought to help them turn these into sort of conversations with the board about the strategic planning and the growth plans and what obstacles may be along the way, which is a slightly different way of framing it, isn't it? From problems 1 to 10, can we talk about how much resource we can have to actually head those off of the pass, particularly when the spectrum of different kinds of risk gets wider and wider and wider. So take your company, Tim, in Southampton. It's not just about football. I'm sure I don't need to tell you that. It's about data. It's about monetization. It's data. It's about corporate transactions. It's about contractual, et cetera, et cetera, et cetera. So where does one stop? I think the other area that we find corporates we're encouraging them to focus a little bit more on in terms of the planning is risk transfer and insurance. Now, insurance obviously is the fallback position. When things have happened, one doesn't particularly want to have to get the policies out. But when they do happen, one does have to get the policies out. And there is sometimes quite an alarming lack of clarity in relation to, okay, which of our risks, and we're talking often big risks, could be cyber, could be a competition, follow-on damages claim, could be a data breach claim, it could be a consumer class action. Which of those are insured, which are uninsured? Of those that are insured, to what extent might our exposure be covered? And we're seeing more of a willingness to look at those risk transfer issues more holistically. So in other words, getting the lawyers and the brokers to work together to not to over-engineer it all, but at least to try and give some clarity for the corporates on, okay, well, where are we on our risks? And if we do need to fall back on insurance, to what extent are we going to be covered? And to what extent do we need to get the lawyers and the brokers to do a bit more to actually plug some gaps, or at least identify gaps that cannot be plugged in, for example, a hard cyber insurance market. Okay, thank you. That's really useful. Thank you. So moving on to our theme 2, second theme, if we may, which is around creating value, and around which I mentioned we are looking at through 3 lenses that I outlined earlier on. And so creating value through understanding litigation risk, we've touched on it already, but Graham, from your perspective, do you feel that lawyers who are able to help build litigation and regulatory risk into corporate strategy are the ones who are seen as the gold standard, if you like, by business? In other words, that the value is then obvious.
Yeah, absolutely. And hi everyone, by the way, nice to meet you all, nice to be part of this. Yeah, and picking up from what Tim said as well around one of the things we find works really well with raising this as an agenda for the board or your exec team is picking up on past events or things that have happened to really kind of facilitate this in the minds of the board. So our business as an online reviews business is heavily kind of engaged with kind of consumer trends or political trends around what's happening in social media, for example. And there's not a day go by when we don't see Facebook in the news or kind of Google or YouTube around their content, whether it be disinformation, fake news, illegal content, and seeing those companies being gone after by regulators really focuses that in the minds of our leaders, and that's something that we do to embrace risk, is say, look, these things are happening, this has happened to someone else, this could happen to us, let's look at this and see what we can do before it even happens. And that's things like being very proactive about the way we handle illegal content, proactive around the way we deal with fake reviews on our site, for example, and again, it's building that into the strategy and aligning your risk strategy to the company's strategy. And our business is all geared around trust, and our mission is to become a universal symbol of trust. And the only way we do that is ensuring that there are trust in all of our processes. So we've been fortunate in the sense of our risks are also our identifiers, in the sense of if we manage the reputation angle from our risks, we're progressing our strategy. So I think being able to align your risk strategy to your company's strategy is really the key to being successful.
Yeah, no, that absolutely makes sense. And I think your point as well, Graham, around raising awareness with the senior management, with the board, around what's happened to other corporates is, as you say, valuable, because it just demonstrates that you're not necessarily saying that will happen to your business, but it's just highlighting that things do happen. And it also highlights the emerging trends for the business as well, just so that everybody can keep an eye on what might come around the corner. And I was just before this webinar having a look at and just having a think about some of the major trends which we all read about. Multi-claimant consumer litigation, so the class actions effectively, are absolutely on the increase. And there are a number of drivers for that. And I mentioned that and I mentioned the trends because it is relevant again to the concept of building value and understanding litigation risk. But the drivers for that particular risk include the litigation funding. There's increasing amounts of capital out there, which is often driving some of the big litigation that we see. The emergence of well-organized and well-funded claimant law firms, some of whom are sort of moving in from the US, but certainly not all of them. Consumer empowerment, the number of reforms proposed by the government, recent consultation by the government in relation to improving the processes for consumers to seek redress for, amongst other things, anti-competitive conduct by corporates. So multi-party litigation is definitely emerging risk. Competition litigation in that context we're seeing more and more of that in a number of different sectors, whether that's a lot of it through the Competition Appeals Tribunal, so whether that's Merrick's to MasterCard or recent claim against Apple in relation to iOS device owners, truck cartel litigation, etc., etc. The list goes on. So it is, as I say, it is increasing in terms of category of risk. But that is just what and the whole regulatory regime is changing post Brexit, of course. So there is now an evolving scenario, an evolving regulatory environment, whether that's digital or competition. So again, that creates some uncertainty from a regulatory perspective.
Yeah. Certainly from our perspective, we do have interest in class actions at the moment. We have one which we would say is meritless, but you're still stuck in a litigation case which goes on for some time and incurs a lot of costs, and it's difficult to be able to say to the board why is that the case. And picking up on the point earlier about insurance, I don't know what others are finding, but we are finding that insurance premiums are just skyrocketing because of class actions, and it's really difficult to get the cover that you need. We were fortunate enough to have a bit of cover around legal costs with the particular claim that we have, but have since been told we will no longer be insured, which is, it's kind of a really difficult kind of vicious circle, because they're on the up, but also insurance is not looking to cover it. So it's so important.
Yeah, we've noticed a similar trend actually probably on both sides of the coin, with certainly being invited to be part of claimant groups increasingly, which is quite an interesting phenomenon, and actually probably hints a little bit at where in-house as lawyers we can help drive some value actually with looking at where there is actually merit to claims and where there isn't, and when to get involved in litigation and when to not. Because I think that what there is a trend within certain teams internally where something goes wrong, right, let's sue everyone and let's get our money back and then some, and actually it's never quite that simple, and disappearing off down the litigation rabbit hole, only to then find yourself a lot of time and a lot of money out of pocket is not a good place to be, and can lead to some difficult questions. So I think that's certainly one element that we've noticed. But I think actually within sport particularly, you can see that there is definitely potential for some class actions coming in the not too distant future with events that are around at the moment. And it'll be interesting quite how those pan out, because obviously they start to go back quite into the past and look at past behaviours, and how they work out will be interesting for a number of different parties, clubs, organisers, and regulators alike. So you can see the rise will definitely continue.
Yeah, and I, as you say, Tim, there is sometimes discussion around whether litigation or claims can effectively be an asset, a money generating thing, and usually they can't. But occasionally they can. If one is, usually it's when one is part of a larger group of organisations bringing some kind of proceedings, because then there's economies of scale and normally funding is behind it, and there's some adverse cost insurance as well. So but normally it's an exposure. And I mentioned before the fairly bold statement that usually litigation can be avoided, and this again comes back to creating value, and the increasingly sophisticated approaches that are being taken by some corporates to spot emerging litigation at a very early stage, whether that's a business-to-business dispute that could escalate out and get out of hand, or whether it's a regulator who is showing some interest, or whether it's a class, or whether it's an increasingly active group of consumers on social media who are beginning to make a fair bit of noise. Whichever of those it is, early warning signs are key, and early strategies for mitigation are key in terms of steering it, and very often it can make a big difference. I mean, one of the case studies that I often talk about, which is in the public domain, but which we were directly involved in, was the post office group litigation, where we happen to be on the claimant side on that matter, because we tend to want to do some work on the corporate defence side and some on the claimant side, so that we get insight into both worlds. On that one, post office, again, which is public knowledge, decided to fight extremely robustly all the way through to a couple of long trials. The effect of that was that it generated an enormous amount of adverse publicity for them and others, and some very significant costs in terms of damages as well. Now, whether all of that could have been avoided, prevented, mitigated by a different approach having been taken many years ago, is something that they will probably have their own views on, one would have thought. I would have thought government, who owns them, has views on that as well. So I'm not seeking to criticise the lawyers involved, whether external or internal, on that case, but on a simplistic level, the stakes got higher and higher for post office on that particular case, and I suggest that it could have been slightly different had they taken a different course earlier on. So that is an extreme example of what can happen when the early signs of a problem are not managed in a way that the company might want them to do. So moving on to theme 3, which is around shaping strategy. And I think at this point, Joe, if we could maybe move to the poll question for those viewing.
Absolutely, yeah. We're going to have a poll come up on your screen in a moment, ladies and gentlemen. So if you could respond to that whenever you're able. So this is, in your opinion, does your company currently embed litigation risk management into its business strategy? Basically, we're trying to get a bit of an idea about how far businesses are really going to identifying risk early on, which I think we've been speaking about, is pretty key. Can everyone see the live updates? Because it's quite interesting. It's almost 50-50. I think we'll give 2 minutes maybe for the voting. And while we're waiting for that, I was wondering if I could pose a question to the panel, if I may. We've had a couple of questions come in. I suppose this isn't entirely related. Well, so one of them is, did any of you see force majeure clauses successfully invoked related to COVID?
So I guess I mentioned this first in a quick way at the beginning. I've seen it attempted to be invoked.
Yeah.
Previous draftings and iterations of it pre-COVID. I haven't seen it successfully in terms of it taking all the way through to litigation.
Right.
But certainly it's been an issue that I've seen on the table and has been discussed, while potentially somewhat debated as to whether or not it was covered. But keen to hear other people's experiences on that.
Yeah, I think we saw similar. I think we saw it as a way that certain organisations tried to get a foot in the door of getting out of certain relationships that they may be wanting to end early for other reasons. So we had a couple of quite strong attempts actually head our way that we were able to shoot down quite early on actually, and through being quite well prepared for it by having some arguments lined up, but also actually knowing the agreements that were in play and actually having an in-house team that could advise quite quickly in terms of what we might use.
You had an idea that this might come up then, basically. Yeah,
we had a bit of a feel.
Yeah, fair enough.
Yeah, just really with high value contracts being around and people not necessarily receiving or perceiving themselves as having received all of the rights that they had under those contracts. So, I think that it was always likely to happen. I don't know how many went through successfully. We were able to get to a negotiated position that worked quite well for us on both. So it kind of worked in our favour a little bit.
Cool. Okay, so the results of the poll are in. I'll share those on screen now. So a slight advantage to the yes poll, which is encouraging, although I suppose maybe not what I was expecting, but I don't know.
Interesting. Well, it depends if you interpret embed in a good way or not, I suppose.
Right, yeah, I suppose that's true, yeah. Maybe embedding it, but not successfully. Yeah.
I suspect the no's are saying that they assume that people are assuming that the company isn't paying enough attention to litigation risk.
Yeah, and I mean it's broad. I mean it's not a million miles away from the survey result, which indicates that 44% felt that litigation and regulatory risks are now an integral part of their business and strategy. So yeah, it's probably not unduly surprising. And I think the natural extension of that question and the answer is. But what are companies actually able to do about it, and how effective is that? That's probably an equally relevant question. And I think one of the other questions that we have here, Joe, is around how can a business achieve a situation where everybody in a large organisation actually understands risk, which is a really good question and a really big challenge. And I think from my experience of working with the corporates, quite often the ones that are succeeding in that are the ones that find ways of I think we touched on this before, actually reframing it not as a negative risk discussion, but as a positive, listen, this it doesn't matter what you call it, risk or something else, it's just a reality of doing business. And if we are doing stuff in the business to make it grow and make ourselves move forward, doing stuff means things are going to happen. So let's talk about what might happen. So there's a danger, I think, of we all use the word risk. We're probably guilty of having framed this whole thing with the word risk all over it, but there is a risk of that. There is a risk of the word risk being overused, and that turns people off.
Yeah, I completely agree with that. Sorry, Ryan, you want to go ahead?
You go ahead. Yeah.
Yeah, I mean, certainly within our business, being a kind of fast-growing kind of tech business, risk is almost a dirty word where, you know, it's corporate, it's something only legal need to think about. So we thought long and hard around how we do that. And again, it was aligning to our strategy in the sense of we call things trust. So, you know, is it a trustworthy thing to do? Is it, you know, it's a trust test. It's, you know, it's to drive the strategy forward. As opposed to, yes, it's kind of me saying you can't do something because it's too risky. So I think it's really important as a business to try and find ways to do that. I mean, our business is slightly unique in that sense, but I certainly think there are other ways to, you know, channel that as a good thing and a positive thing, and a way to, you know, be seen to improve processes rather than point out the risk. You know, particularly with internal audit. You know, we've recently launched our internal audit teams, and again, it's about, look, how can we improve things? How can we make your job easier, and then get this done in a way that's not going to backfire, as opposed to, you know, just purposefully, you know, wading in and saying, have you thought about the risks, as a tick box exercise?
Yeah.
Graham, I definitely echo that. I think it's a great question by the audience member. One of the sort of cultural things I've tried to do is to eliminate what I think is a false dichotomy, having this idea that there's commercial risk and there's legal risk, and somehow they're separate things. Because these are just contracts. You don't even need lawyers to draft contracts. As all the lawyers know, we can agree orally a contract anytime we want to. And the idea that you would just have some commercial people draft some high-level principles and the lawyer to do the drafting of the rest is a very bad way, an old school way of having risk management. You have to get everyone to accept that it's just all commercial risk. That's all this is. And whether you're in a highly regulated area or not, you need to appreciate these factors. And I think that is sort of the cultural change you need to drive internally at the board level, and then obviously, you know, throughout the organization, to try and, you know, to answer the person's question, get everyone to actually value and accept risk in the whole organization.
Yeah,
absolutely. I did just a question actually for any of you, Ryan, Tim, or Graham. It's around corporate social responsibility, CSR, and ESG, and whether and the sort of doing the right thing concept, which of course is increasingly on our agendas. Do any of you see that as as an area of difficulty which can sometimes create tension for the in-house legal teams and the business, in terms of trying to encourage whilst seeking to achieve the objectives of the business being the foremost objective, but at the same time having one eye on ensuring the business goes down the right route in terms of doing the right thing environmentally, for example, or socially? Do you see that as creating any kind of tension, or do you see that as an easy issue because the more forward-looking businesses see that as an opportunity to enhance reputation, enhance value? I'm interested in how you see that.
Yeah, I think for us, it's definitely an opportunity. We'd see it as a way to link some of the ways that we'd like people to work into kind of an overall strategy. So we've actually just recently launched our overall sustainability strategy and did it relatively publicly, which is quite helpful actually. It gives us a standard that everyone has basically said they're going to work to. We very deliberately made it kind of a fully integrated strategy where we included things like not only just environmental performance, but things like safeguarding, crowd safety, and how we interact with kind of fans, communities around us. So it's quite a wide, broad piece, but actually it starts to do that education piece for us internally, around, okay, how are we working as an organization? What's our appetite really for risk, and where are the areas where we may or may not take certain risks, and realize kind of commercial opportunities that exist. So for us, I think it's been really positive and really useful, and I think that it will continue to grow. I think that it gives us the opportunity to really have that dialogue with a number of different teams, and to lead them through, okay, if you take this action, here's the possible outcomes that could arise from it. Are you prepared for them? And how do they actually align with our, not only our kind of club values and overall vision, but actually how do they align with our sustainability strategy, which is out there in the public? And are you, it's the old newspaper test, are you going to be happy to explain this and explain your decision making?
That's really interesting, because that again, that aligns with what we're seeing in our advisory work, where the companies, it just creates the context for all sorts of decisions being able to be taken a lot more effectively. So where there is the sort of what you've described is a shared language and understanding of current purpose, strategy, and behaviour, and that when there is that, what we see is when there is that common understanding, then whatever the decision is that has to be made, or whatever the event that occurs, or however tough things get in terms of litigation, for example, the decisions tend to be a lot easier, because everybody's automatically starting from the same place and looking to get to the end result together. So it does make it a lot easier, a lot more effective is what we've seen. Okay, thank you for that. And just back to the themes really, and strategies for litigation risk control and regulatory risk control. We talked about building a culture and attitude to risk management across the business, so making sure people do understand the risk inherent in the business. Turning to you, Tim, again, in your sector, what steps do you think can be taken by companies generally to strengthen their position when actually handling litigation and regulatory situations? We have touched already on the preparatory steps. Were there any other areas that you think companies could?
Yeah, definitely. I think in terms of kind of preparatory steps, I think that what I have seen kind of throughout the course of my work everywhere is that testing ahead of time really works well. So start with things like mock dawn raids and work like that has worked really well actually in preparing people for the dreaded day when someone arrives at their desk and asks to do a search of all of their emails and other materials. So I think that kind of planning ahead is really, really good. I think that beyond that, I think actually it's an approach to work and really knowing and understanding what we've got, how we're working. So I think having written records, written processes, clear policies that actually people stick to are quite helpful. Having people trained and aware that those kind of policies, processes, working procedures all exist really help as well, so that there's actually, if anyone does come and ask, there's an understanding of how things are working. We've seen with particularly historic cases where literally nothing was around, because a lot of some of the cases actually predated even kind of emails and computer records really being available to us. So working on those shows how difficult running any case can be when you're totally blind. It sounds really obvious, but actually it's quite surprising how frequently the golden piece of information just isn't anywhere. We know it's there somewhere and it exists in someone's head, but we've got no evidence of it and evidence of the conversation. So I think it's that really for us is really key, and we see that as the way to defend ourselves if we need to, or actually a way to pursue any actions that we need to do. It allows us to work out the strength of any particular case pretty easily.
Yeah, and that sort of response planning and outcome scenario planning, it can be really simple for some businesses, in the sense that it can be as simple as identifying the individuals within the business that will have responsibility for responding and pulling together the response team when a situation arises in a particular area, whether it's competition or data or whatever it is. So therefore everybody immediately knows, okay, who knows who is going to be dealing with it, both internal and external support. But having said that, when a piece of litigation occurs, the sort of response planning, or the outcome scenario planning rather, can be very complex. And Ryan or Graham, I don't know whether you've had an experience of outcome scenario planning in litigation, because I'm interested in whether corporates feel they are getting what they need from external advisors in relation to outcome scenario planning. And what I mean by that is, if, for example, there was £1 million claim being threatened against the business, either by a counterparty, and the board is being advised, is being asked to make a decision about strategically where to go, whether to settle it, whether not settle it. What we often find is that boards welcome a more scientific approach to outcome scenario planning. So financial outcome scenario planning, upside, downside, not in a ridiculously detailed Excel spreadsheet that the board has not got time to go through, but a visually driven document that very clearly shows them, right, if we go down route number one, that is the upside or the downside. We go down route number two, etc., which does need to be presented in a visual and simplistic way, but is a complex thing to produce. I'm just interested in whether or not that type of thing is something you have seen or would like to see more of. Graham or Ryan, really?
Yeah.
Graham or Ryan?
So yes, absolutely, I've seen it, and I think that's how one of the factors I use to distinguish good external counsel from perhaps not so good. I always expect a briefing on the substance of the matters, and the board, obviously, general counsel, I'm going to get all the technical information. The board will want a rough assessment of that as well. But then, almost even more important than that is, in effect, a PowerPoint presentation or a structure diagram of steps of sort of what are often not necessarily binary choices. If you can simplify it, that's great. But risk-weighted probabilities of what will happen if this, then that, and consequential value impacts. And I have seen the Excel version of that too. And when we have quantified that, and frequently are asked sometimes by our auditors at the end of the year, what are the contingent liabilities of the business? How would you assess the current litigation risk across all areas, which involves making that very financially driven assessment, aside from the fight you want to have on the matter of substance. So I do see that, and I think it's very valuable.
Yeah, I certainly think from our perspective we could probably do more around that area. But I think for us, one of the key things with litigation is reputational risk and how you kind of quantify that. Many of our claims relating to the platform might not be financially significant, but it could be hugely significant for our business model. For example, there was a claim this year, which is in the public domain, between a law firm and a reviewer who had posted a review about the law firm being scam or scam artists. And whilst the claim was actually low value, for us it's a really important matter to get right, because if we're going down the route of reviewers being almost sort of censored, it impacts our business model. So for us it was a very important case to pursue, in the sense of, well, the claim was kind of made in without our involvement, and an order made to kind of remove the content. But we pursued that because we think it's fundamentally wrong, and we think the judge got the wrong judgment around defamation. But the claim in itself was only worth kind of 20,000. So on a pure kind of financial metrics, we wouldn't have gone down that route, but actually from a business model protection perspective, it was really important. So I think financial models definitely do help, but I think it depends on the style of your business and also
This is a really valuable point. It's about being very, very clear, isn't it, about what is at stake here for the business. Is it reputational? Is it financial? Is it both? And then the strategy and decisions around that.
Yeah.
I mentioned earlier on the area around risk transfer, litigation risk transfer, and insurance strategies, and there are two angles to that. On the one hand, there is the sort of post-litigation insurance and funding world, which is evolving, and corporates are tuning into that more in terms of the opportunities for transferring adverse cost risk, etc. But on the other side of it, which is the more traditional insurance side of business, and the risks that are insured or not insured, or insurable or not insurable, in your experience, again, throw this open to any of you, Tim, Graham, or Ryan. Do you see corporates, either within your business or more widely, having sufficient visibility over what's insurable, what's not, and whether there could be a more holistic approach taken between lawyers and brokers, for example, to work together to ensure that the corporates do have that visibility? I'm just interested in your experience of that area.
Yeah, sorry. We've probably got mixed experience, actually. So we have got that at times, that holistic approach where we've got quite a good relationship with brokers, and we have a good regular work through. And I think it always works quite well until something goes wrong, which doesn't it always? Which really then actually I think some of the work around policy details and what's in, what's out, what type of cover we're talking about would be helpful. I think it's pretty hard to front load that, because there's so many different types of events that could hit anyone at any one time that that you can't get all of them. But I think actually a bit more of a succinct overview of policy and cover would be quite helpful. I think particularly at board level would be quite helpful.
For major risks in particular, I guess.
Yeah,
because
I think so.
It can't be done across the whole business, across every risk. It would just not be viable. But some of the big, the major risks, which
I think those big risks would be, and I think, particularly around cyber data and those types of risks, I think that they can be so complex that people don't always get what they think they're getting. And so actually, I think that actually making the decision on those and on the levels of cover and getting those right is really, really important. But actually, so at times is a decision that's made a little bit in the dark, and it could be kind of given some value with that really good close relationship.
Yeah. I'm just looking, Joe, at any of the questions that have come in from our audience here this afternoon. And I'm just looking at one of these, which question being, you said the boards are now much more aware of risk than they were in the past because of financial crisis, COVID, etc. How long until complacency returns, or is it gone for good? Interesting question. Anyone any thoughts on that?
Personally, I think it's probably not gone for good. I think that it's human nature that the next kind of threat or opportunity comes along and you forget a little bit of what's gone in the past. I think things have changed. I think probably to link both questions a little bit. I did a session the other day, and my role actually sits on the board, which I find really, really, really helpful and really valuable in terms of giving me an overview, but actually giving me an immediate voice with everyone else just to find a way to actually get certain risks taken seriously and to flag them strongly if need be. Found at times it's quite good to shock and quite good to come in with some pretty punchy brief statements that might shock a few. You know, I've done it in the past in a meeting where we put up some direct quotes from people internally around a certain issue that surprised a few. That A, was an issue internally, but B, that those quotes were ascribed to people internally as well. So I think it's finding a way to get the message to land and influence people and have that impact. And you know, there's nothing quite like data, but actually the short, sharp shop can also work. But I think it's easy for me in terms of having my voice at board level, which is helpful. I was a little surprised by some of the other responses that then focused on how difficult that could be from kind of almost a conflict of interest type point of view, where I think that for me the positives far outweigh that, and far outweigh kind of the more traditional maybe lawyer role within the company. I think that my ability to advise on risk directly is really helpful to me, and means that actually we can manage that complacency a little bit.
Yeah, I'd certainly echo that in terms of our business. I think it's hopefully here to stay, and you know, we you know, even to the extent of we have now a dedicated committee to deal with trust and transparency issues, which are, you know, as I was saying, it's kind of really kind of you know, risk badged as something else, and you know, that feeds up to the board. We've also appointed a chief trust officer, which again is kind of, you know, really kind of tantamount to you know, how important it is for us as a business. So I do think boards are taking it much more seriously now, and you know, particularly if a traditionally kind of chaotic, kind of fast-growing technology business is doing it, I think, you know, hopefully there's kind of you know, hope for all businesses.
Yeah,
and have you found, and Graham, have you found, asking you because of the particular trust focus that you've got in the business mode, do you find that for your team, for the legal team, to demonstrate value and communicate value, it helps to shape your initiatives and your messaging around the key strategic languages such as trust? And from the sounds of it, that is exactly what you're doing, because then the board immediately understands, right, okay, we're talking about a core strategic issue here. It happens to be a particular thing that the legal team are asking us to do or adopt resource to, but it's core.
Yeah, absolutely. I mean, I think there's two things that have really helped us of late around just embedding trust into the business. One is the trust messaging around just it being a key differentiator for us, and two is our IPO. I think there's something like the stick of, you know, now we're public, we have to do this. It's certainly kind of helped us, and I think even the process of our IPO, and many businesses might be going through the same thing, it really focuses your mind in terms of what your strategy is as a business and what you put in your prospectus. And I think that's really helped us, you know, build the equity story, build, you know, the reputation angle around our trust, and therefore kind of risk is almost kind of, you know, slipped in the kind of headwind through that. So that's certainly been you know, very helpful for us as a team.
Yeah. And also, I was just going to ask, Ryan, I don't know whether you've got a view on this one, but it's in relation to external counsel, external law firms, and obviously without any of us mentioning any particular firms or lawyers, or indeed without being specific about the firms that you use, but generally speaking, from what you see, which are the external counsel who are demonstrating the most value? And one of the areas, and I'm talking about litigation and regulatory in particular, because one of the things that we do hear quite a bit is the appetite for corporates to want their lawyers to deliver value on insight rather than process. And so an example of that is an understandable concern expressed by corporates generally to the legal profession around significant costs being incurred and spent on, for example, disclosure exercises. Sometimes it has to happen, but can often be done a lot more efficiently. So I'm just interested in your your view from in-house counsel looking outwards on what's working and what's not really?
It's a great question. Obviously, one of the earlier points I mentioned about being strategic with your commercial and commercial with advice is appreciated. I think also an understanding of our business. While it may, in a very crude way, be better for law firms to be good litigators and just defend us again after again and again in particular matters, the ones that I think excel can actually be quite proactive about that. They can identify problems, structural problems that might exist in our business that are causing not just our litigation, to potentially have issues, but broader reputational risks, as the others have talked about previously. And that's the type of that relationship you want, where you'll have, it could be a commercial, a partner on the other side, a relationship partner, it could be some senior associates or juniors who will sort of keep in touch and just, talk about issues that they have been seeing generally in the industry or in their particular field of expertise that might be relevant to you. And then that's things that we can keep on adapting internally and try and prevent future litigations occurring or future risks occurring. So that's one of the sort of close relationship is things that I see in the firms that I value.
Yeah. And it's in many ways, I think that's coming. That sort of takes us back to a point that was made a little bit earlier on, which is for the legal teams, internal and external, the starting point being what matters to the business, in terms of the business's objectives, and then working back from that as to what needs to be done to achieve that. Which also links to one of the other questions we just had actually from the audience, which is around whether the panel feels that that external advisor law firms are too often too aggressive in litigation, despite even if that doesn't align with the business's objectives. And I understand where that question comes from. I mean, as litigators, we see no less aggressive approaches than we ever saw, and it just happens that a lot of the aggressive litigation is done in a way when the court won't see it, and that's nobody's defending that, but that happens to be a tactical way that some firms operate, and then the question that begs the question as to whether that kind of aggressive litigation is ever acceptable, and certainly the court would say not actually, but whether more personally it ever achieves or can achieve long-term objectives of the business. And I think everything we're talking about here would indicate that it wouldn't often achieve them. But certainly from a litigation lawyer's perspective, I think there's a difference between being aggressive on the one hand and on the other hand, robustly challenging arguments or claims that are not accepted by the business and are unfair as well, apart from anything else. So there's absolutely nothing wrong, certainly in our experience, in our view, in taking a robust position in relation to the company. But all roads need to lead back to what the objectives of the business are.
It's interesting. I mean, keenly hearing in Tim and Graham's perspective on this, sometimes I feel when litigation comes up that obviously my internal side, whoever has been offended internally commercially, is chomping at a bit to sue the other side and have a fight. And to the questioner's point, sometimes the external counsel is probably, we've got to become egging it on. And it's often me and the internal legal team going, hold on a second, let's just have a think about this and trying to calm everyone down. But I don't know if that's the experience across the board. But I certainly do value when I get the opposite sometimes, that external firms point out weaknesses, point towards mediation and other options as opposed to just charging ahead. But keen to hear people's thoughts on that one.
Yes, certainly completely agree, Ryan. And I suppose you, from the other end as well, around defending litigation, the commercial teams who are involved in that, or this is nonsense, it should go away, and then you've got your litigators saying, well, we can go ahead and do this, and then you find yourself trying to think, well, okay, we've got to balance costs and we've got to balance our time, we've got to balance our resources, and certainly from an internal perspective, we do find ourselves in that position. Picking up on the aggressive point, I think like anything, there's a range of lawyers out there, and some are aggressive, some aren't. And I think what you said, James, is really important in the sense of it comes back to what is the company's strategy? What's most important to it, and aligning your approach to that. And it's the value add around, yes, we could go off and defend this claim, but ultimately, if the strategy is to maintain the reputation of the business, or there's a reason not to do that, then you have to look at other strategies. And take the class action case I mentioned earlier. We fundamentally disagree with the claim and think it's completely meritless, but we're left in a position where yes, you could sink another 5 million worth of cost in the US and class action claims. Do you want to do that? And all of those things you have to balance. And I think the more value add your external lawyers can provide to that discussion, rather than just aggressively defending the claim, the better, really.
Yeah. One of the other questions that we've got here is around back to the sort of central question of can risk create value, and effectively how does risk create value? And I think what we've drawn out actually during the course of the conversation is that yes, it can, and there are different ways in which that can happen. Not least, well, one example is if a business is faced with an emerging dispute or an embryonic dispute where the stakes could become very, very high indeed for the business, and which could then lead to reputational damage. If the legal teams spot that quickly and work with the business to steer that to a very early resolution, which neutralizes the risk of adverse publicity, neutralizes reputational risk, and enables the company to continue on its strategic track. That is the creation of value by the legal team, whether it's internal or external. So I think that is the answer to that question that's been posed. But I don't know whether Ryan, Graham, or Tim, whether you've got any different perspective on that.
No, I think, economically, risk and value are the same thing, basically. They're pricing of risk equals value. In terms of a legal perspective, absolutely identifying critical issues within your business that are not just affecting litigation risk, but brand damage, reputational risk, just annoying customers, basically, things like that will hurt you. If you can identify that proactively, even if it costs you litigation or two, and then put in steps to solve that and be efficient across it, you'll certainly create value, not just in terms of minimizing future costs and future damages payouts, but you'll make processes more efficient. You'll make customers or your end users more happy. So that's kind of key. And it's not just a legal, as I was saying at the beginning, it's not just a legal position either. It's something that can be commercially shared across the whole business in everyday decision making.
Yeah, I'd agree with that. And I think beyond that, I think the other way that knowing and understanding your risk really can drive some value is it does allow you to push the envelope a bit. So if you know that something is a little bit risky and a bit higher risk, and seen it in the past with certain kind of marketing advertising campaigns that ended up being really successful, but actually were a little bit close to the edge in terms of how they might have landed. Knowing and understanding those risks ahead of time allowed us to kind of prepare everyone for any fallout that could have happened. It's one small example, but it does show how you can start to work up to the edge a little bit more if you really are doing that kind of good risk assessment and good assessment of how things might work out on a sliding scale of really good to really, really bad. So, I think that it just allows that flexibility and really starts to deliver some benefits to what you can do, rather than saying no to everything, which is obviously what we all like to avoid doing.
Yeah. Well, on that positive note, I think, Joe, just conscious of time, and I think we've probably reached a stage where we've covered the main points that we wanted to cover. So unless there are any other questions from the audience, but I don't think there are, that needs to be dealt with now, we could always follow up with any additional ones afterwards. But if I could thank very much Ryan, Graham, and Tim, much appreciated. And thank you to everybody for watching this webinar. And thank you, Joe, for hosting it.
Thanks very much, guys. This is one of a series of webinars we're going to do. So thanks very much for watching, and we'll see you all next time. And thanks once again to all of our panel. Have a great evening, guys.
Thanks, everyone.
Thanks, everybody.
Bye.
Bye.